In the previous lecture, we examined some of the problems with lex talionis as a general principle of punishment. Problems like these have led some retributivists to abandon lex talionis altogether. These retributivists deny that how much harm you inflict on others is even relevant to what you deserve. They propose alternative bases for desert. Today we'll discuss one family of theories along these lines. This kind of retributivist theory is based on a duty that you may remember from our discussion of the duty to obey the law. It's the duty of fair play. If a group of individuals participates in a rule-based cooperative enterprise, and each member restricts his liberty in ways that produce benefits for everyone, then anyone who benefits from the enterprise owes everyone else a duty to submit to all its rules as well. The duty of fair play was harnessed for the purposes of punishment theory in the 1960s by Herbert Morris of UCLA. Begin with the observation that my life would be easier and more rewarding if I alone could commit crimes without consequences. I'd possess an awesome power. I could take and use the property of others at will. People would obey me and cater to my needs. I could eliminate competitors and retaliate against anyone I disliked. Each of us would benefit greatly from being able to commit crimes without consequences, while others obeyed the law. It would be like having the mythical Ring of Gyges mentioned in Plato's Republic, or the invisibility cloak from Harry Potter. In the real world, however, the law asks us to obey, to bear the burdens of self-restraint, and it gives us reasonable assurance that others will do likewise. And we do so. Law-abiding individuals bear the burdens of self-restraint, so the criminal law can be viewed as establishing a cooperative system encompassing everyone within its jurisdiction. Law-abiding individuals are cooperators. When someone commits a crime, she partially renounces the burdens of self-restraint. She makes an unjustified exception of herself, taking advantage of the rest of us who obey the law, thereby violating the fair play principle. If she goes unpunished, then she will have gotten away with doing less than others have done. She will have benefited at our expense. The purpose of criminal punishment on this theory is to effectively take back the advantage over the rest of us that the criminal unfairly gains when she renounces the burdens of self-restraint. This suggests a theory of desert very different from lex talionis. Instead of proportioning punishment to the degree of harm caused, unfair advantage theories proportion it to the benefit gained by the criminal. Keep in mind that the relevant benefit for the purpose of unfair advantage theory is intangible. It never takes a physical form. A shoplifter might acquire a blouse, but the blouse is not the relevant benefit for the purpose of this theory. If it were, then unfair advantage theory would recommend that the state punish her simply by taking back the blouse. Of course, the shoplifter is legally required to return the blouse or compensate the merchant, but this is no punishment at all. The benefit to the shoplifter is the intangible value of having gotten to break a rule that the rest of us obey. So unfair advantage theories don't make the punishment proportional either to the harm caused or to any tangible benefits received by the criminal. This feature nicely reflects the realities of existing criminal law. Many felonies cause no harm. Many crimes don't benefit the criminal in any tangible way. Consider an unsuccessful attempted murder. It harms no one and doesn't benefit the criminal, but it's a serious felony. Other inchoate offenses, like solicitation and conspiracy, are likewise harmless. They don't benefit the criminal either, without a successfully completed crime. Traditional versions of retributivism have difficulty justifying any punishment whatsoever for such crimes. Therefore, retributivists who support the current policy of punishing inchoate offenses should consider unfair advantage theories a promising alternative to lex talionis. The most ambitious unfair advantage theorists argue that their theory can help to justify specific penalty schedules. This requires that we first rank different types of crimes based on the degree of unfair advantage associated with each. Suppose we conclude that committing manslaughter gives one a greater unfair advantage than vandalism does. In that case, the theory would recommend a heavier penalty for manslaughter than for vandalism. But how could you estimate relative degrees of unfair advantage? Michael Davis proposes a thought experiment designed to extract this information. He asks readers to imagine a set of licenses, each of which authorizes its owner to commit a specific crime once without legal consequences. There are murder licenses, shoplifting licenses, reckless driving licenses, simple assault licenses, etc. The value to the owner of such a license would depend on what it licensed the bearer to do. A murder license, for example, would give its owner the fearsome power of life and death. People would work hard to stay in your good graces if they knew that you could murder them with impunity. A shoplifting license has much less value by contrast, although it has some value. In other words, murder takes more unfair advantage of the public at large than shoplifting does. Again, the point is not that criminals take advantage of their victims. Of course, they often do so, but that's not the point for unfair advantage theory. The point is that criminals take advantage of the rest of us who'd like to break the law, but obey it instead. Unfair advantage theorists recommend ranking crimes from most severe to least severe, based on the price that we imagine the corresponding licenses would command in an efficient market. The crime type with the most expensive license should be assigned the most severe penalty that we're prepared to inflict. This might be death or life in prison without parole. The next most expensive license gets the next most severe penalty, and so on, until we arrive at the cheapest license and the lightest penalty that's worth the trouble, like a small fine or something. Unfair advantage theory boasts an impressive elegance and generality. It promises to justify punishing the many crimes that cause no harm to a victim, as well as crimes that provide no tangible benefit to the criminal. The theory accommodates a wider range of crimes than earlier versions of retributivism. There are, however, serious challenges that the theory must overcome. One objection is that it depends on a reliable rank ordering of crimes. How are we supposed to determine which licenses would command the highest prices in an efficient open market? Michael Davis envisions an auction for the licenses. This isn't a policy proposal, it's just a thought experiment. Davis asks us to imagine that a new criminal justice system is about to be launched. The authorities print a fixed number of licenses like the ones I described before. Everyone receives a certain number of credits to spend. The licenses are auctioned off one at a time to the highest bidders. After that, the licenses can be traded. Davis argues that the higher the price a license sells for at the auction, the more serious we should understand the corresponding crime to be. If kidnapping licenses sell for 75 credits and burglary licenses sell for only 25 credits, then that means that kidnapping is a more serious crime than burglary. It tells us that a kidnapper actually deserves more punishment than a burglar. The purpose of the thought experiment is to get us to think systematically about the relative seriousness of different types of crime. Davis argues that the sentencing schedules that exist in a real legal system are justified only insofar as they reflect the rank ordering of crimes that would emerge from this imaginary auction. In support of his theory, Davis directs our attention to an interesting conundrum that I'll call the vehicular homicide paradox. Involuntary manslaughter is defined in many states as an unlawful homicide, unintentionally caused by an act, which constitutes such disregard of probable harmful consequences to another as to constitute wanton or reckless conduct. Think of someone who accidentally kills his friend by misusing a chainsaw, or by serving him poisonous mushrooms from the forest. Killing someone by accident isn't always a crime, but it is if you were reckless. In addition to the crime of involuntary manslaughter, most states today have a distinct crime of vehicular homicide on the books. The thing is, vehicular homicide is defined just like involuntary manslaughter, except that vehicular homicide has to be committed by means of a motor vehicle under your control. In other words, if you hit and kill someone while driving recklessly, then you're guilty of vehicular homicide, not involuntary manslaughter. But Davis points out that the penalty range for vehicular homicide is lower in every state than the penalty range for involuntary manslaughter. In the state of Illinois, for example, involuntary manslaughter is a Class 3 felony, carrying a sentence of 2 to 5 years in prison. Vehicular manslaughter, by contrast, is a Class 4 felony, with a sentence of 1 to 3 years. This difference is difficult to explain if you focus only on the harm caused and the offender's mental state. In both cases, the offender acted recklessly and death resulted. Dying from poisonous mushrooms isn't worse for the victim than dying in a car crash, and the reckless mushroom cook is no more blameworthy than the reckless driver. Now, some people will conclude from this that current law makes no sense. Maybe we shouldn't classify reckless homicides differently when they're committed with a vehicle. But Davis thinks his theory actually makes sense of the way the law works today. He points out that a license to commit vehicular homicide is worth less than a license to commit involuntary manslaughter. An involuntary manslaughter license is much more useful to its owner. A license to commit involuntary manslaughter allows you to kill recklessly in any way possible, including with a vehicle. Whereas a license to commit vehicular homicide is restricted to reckless killing by means of a motor vehicle. In an efficient market, the involuntary manslaughter license will go for a higher price because it benefits the owner to a greater degree. According to Davis, that fact rationalizes the higher sentences for involuntary manslaughter that exist in the real world. Do you find his argument persuasive?